Hello again. My name's David Winch. I'm a chartered accountant and a director of Bartfield's Forensic Accountants. And in this webinar, which I've unimaginatively called Yet More Leading Cases in Confiscation, we're going to look again at some, I hope, interesting cases and what we learned from them in terms of confiscation under Proceeds of Crime Act 2002. So there'll be a quick introduction, and then the first topic is going to be the benefit obtained by a conspirator. Then we'll look at the benefit obtained as against the loss to the victim and consider if those two are just two sides of the same coin or if they are in fact two rather different things that we need to be aware of. And then moving on, we'll look at money laundering and confiscation. And indeed, we'll find that there is a little bit of an overlap between some of these topics. And I'll wrap up with a few words on how Bartfield's Forensic Accountants can help you. Okay, introduction. So some more of the topics in confiscation today, which cause some confusion and some difficulty. We'll be looking, as we have been over the last few weeks, at statute and at case law to help us out. Remembering that we were enjoined by the House of Lords in the case of May to have particular regard to the statute and not to get too waylaid in labyrinthine complications from case law. All the cases that I refer to are available, the judgments are available for free on the internet, on the Bailey website. The address is there for you. So, benefit obtained by a conspirator. First of all, let's remember that in confiscation, we look at a defendant. We don't look at a group of defendants in a single Section 16 statement or a single confiscation hearing. We look at each defendant individually. So the issue where there's been a conspiracy, let's say a conspiracy to supply controlled drugs or a conspiracy to defraud, the issue in confiscation is not going to be what did the conspiracy obtain, nor is it going to be how long did the conspiracy last. Instead, the issue is going to be what did this defendant obtain, either solely or jointly. And perhaps we will also want to know for how long was this defendant engaged in the conspiracy. So we're looking at the role of the individual defendant when we're considering his benefit from being a member of a conspiracy. And of course, when we look at his available amount as well, we're going to be looking at the individual defendant. The issue of for how long was this defendant engaged in the conspiracy might be important if the offence is not one of those which is listed in Schedule 2 and the prosecution assert that this particular defendant has a criminal lifestyle. And the reason is this, that under Section 75, which defines criminal lifestyle, there is a criminal lifestyle, the defendant has a criminal lifestyle if he has been convicted of an offence which has been carried on for at least 6 months and from which he has obtained a benefit of at least £5,000. Have a look, for example, at the case of Louboutin, which is quite an old case from 2003. In that case, there was a conspiracy which was interrupted by the authorities, and this particular defendant, as it happened, had only joined the conspiracy on the very day that the police turned up and raided. So his involvement in that conspiracy was limited to that one day. And perhaps more relevant for the criminal lifestyle issue, there's the case of Bajwa, if I've pronounced that correctly, in 2011. And this was a case involving fraud. And the conspiracy was active for a period of greater than 6 months. But individual defendants in that conspiracy, some of them were involved for less than 6 months. And it was a conspiracy to defraud, so not a Schedule 2 offence. So those particular defendants who had been involved for less than 6 months and who had been convicted of only one offence, which was the conspiracy offence, did not have a criminal lifestyle for confiscation purposes, even though their co-defendants did, some of them, because they'd been involved for longer. Note that the period that's specified on the indictment itself is not going to be determinative of the period over which any defendant has been engaged in the conspiracy. That has to be based on findings of fact, either by the court or on facts admitted to the court. So just because the indictment says between the dates of 1st of January and 30th of September, Mr. X was involved, or Mr. X conspired to defraud, doesn't mean necessarily that he has been engaged in that conspiracy for more than 6 months, or for at least 6 months. There's a very useful summary of the position regarding benefit obtained by a conspirator in the case of Rooney from 2010. The Court of Appeal went through the case law and then they summarised it very helpfully in this way. As we understand it, said the Court of Appeal, if a benefit is shown to be obtained jointly by conspirators, then all of them are liable for the whole of the benefit jointly obtained. So we may well have a case where everybody in the conspiracy jointly obtains whatever's obtained by the conspiracy, and in that case, each member is liable for the whole of the benefit which has been obtained jointly by the conspirators. But that's not always the situation. So they said, if, however, it is not established that the benefit was jointly received, but it is established that there was a certain sum by way of benefit which was divided between the conspirators, yet there's no evidence on how it was divided, then the court making the confiscation order is entitled to make an equal division of the benefit obtained between all conspirators. So in other words, if we've got a conspiracy and we know that the conspiracy as a whole has obtained £500,000 in different places at different times, but that hasn't been obtained jointly by all of the conspirators. It's some's been obtained by some and some's others, but we don't have that detail because, let's face it, people engaged in a criminal enterprise may not keep those detailed accounting records, which accountants would love to see. Then the court is entitled to do rough and ready justice by dividing the benefit equally between the conspirators. Just remember, this is where they have not jointly obtained benefit. However, if the court is satisfied on the evidence that a particular conspirator did not benefit at all, or only to a specific amount, then it should find that that is the benefit he has obtained. So if you do have information, if the court does have information, if the court is satisfied, for example, that a particular conspirator was going to be paid £1,000 for his role, and that is all that he obtained, then his benefit will be that £1,000 which he obtained. Okay, so that I think is a helpful summary from the Court of Appeal as to how to address benefit in the case of a conspiracy when you're looking at an individual confiscation order. Let's move on. Benefit obtained and loss suffered. Are those two sides of exactly the same coin. Do they always equate to each other? Well, in sentencing, the court is likely to focus on the loss to a victim. And that's perfectly proper in sentencing an offender to look at the loss that the victim has suffered and take that into account in sentencing. But confiscation, if we remember section 76 of POCA, confiscation order reflects the benefit obtained by the defendant. And that's set out in section 76 as to how we address the issue of benefit obtained. And that's not necessarily going to be equal to the loss suffered by the victim. In a simple case, the two will be the same. So consider, if I've got £10,000 of cash under my bed and somebody comes and steals that cash, then my loss is £10,000. That's the loss I've suffered. The thief has a benefit of the £10,000 he's obtained. The two are indeed identical. But in many cases, there's no identifiable loss or victim. For example, where a person is convicted of possession of controlled drugs with intent to supply, there isn't a victim as such, but there will certainly be a benefit, particularly if somebody has drugs on them when they're arrested. Their benefit is going to be the value of those drugs. And there's a whole separate issue as to how do you value those drugs. But that's not associated with a loss to a victim. It's a quite separate thing, but nevertheless a benefit. More perhaps confusingly, there are circumstances in which there is an identifiable victim who has suffered no loss. For example, where a mortgage advance is obtained by fraud, but is fully repaid, then there is no loss to the lender. The victim, the lender is in effect a victim of a dishonest application, but he suffers no loss. But there may well be a benefit. And of course, the well-known case of Weyer is an example of benefit of mortgage fraud, where the mortgage was fully repaid, but the property increased in value, giving rise to a benefit in confiscation from the offence. What about where a lawful and otherwise lawful business is operated but tainted by criminality? The loss to the victim might be said to be the total amount paid by the victim or the amount overcharged by the victim. But is that the same as the benefit obtained? Well, not necessarily. The benefit obtained in cases such as sale or Reynolds was the profit made by the defendant, not the loss suffered by the victim. So that in the case of sale, a contract was obtained by bribery. The benefit of that contract in confiscation terms was the gross profit from providing those goods and services. What was the loss to the victim? Difficult to say. Certainly, you could argue that the loss to the victim was the whole amount he paid, but then he did get valuable consideration. He did get goods and services as a result of his payment. And there's an interesting quote in Reynolds where the court said, "The amount lost by the loser is generally irrelevant, save where coincidentally it equals the amount of the wrongdoer's benefit." And this is the case of the £10,000 stolen from under my bed, or where the wrongdoer has fully restored the benefit to the loser. Because if the wrongdoer has fully restored the benefit to the loser, then you've got issues of proportionality coming in. And the loss to the loser might be relevant to that. But as it says in Reynolds, the amount lost by the loser is generally irrelevant to the calculation of the benefit obtained in confiscation. There was a relatively recent case of Fulton in 2019, where it was a case involving a fraud, a tax fraud, and the laundering of the proceeds of that tax fraud. The benefit obtained by Mr. Fulton was the value of the transactions made by him in the course of laundering monies related to that VAT fraud. And because of the way the fraud operated, the amount of money that passed related to the VAT fraud was not just the VAT, but it was also the value of goods and services. And so the amount of money that was actually laundered was well in excess of the loss of VAT to the victim, which was HM Revenue and Customs. So what was Mr. Fulton's benefit? Was it limited to the loss that had been suffered by HM Revenue and Customs, the VAT that had been defrauded, that hadn't actually been defrauded by Mr. Fulton? It had been defrauded by others and passed to Mr. Fulton along with other monies to be laundered. Well, the court said, no, the benefit is not limited to the loss, to the VAT lost by HMRC. The benefit is to do with money laundering. The money laundering done by Mr. Fulton was not the same thing as the VAT evasion, which had been done previously, the predicate offence, by somebody else. But the benefit Mr. Fulton obtained was the value of the transactions which he made, even though that was a larger figure than the amount of VAT lost. Okay, which brings us on to money launderers. First thing to remember about money launderers and confiscation is that some money laundering offences are criminal lifestyle offences and some are not. And sometimes we see Section 16 statements where the FI who's written a Section 16 statement has taken a money laundering offence as being a criminal lifestyle offence when actually it's not. So which ones are criminal lifestyle offences? Well, the criminal lifestyle offences are Section 327 offences, which are conceal, disguise, convert, transfer, or remove criminal property from England and Wales, or of course, if you're in Scotland, remove it from Scotland, or Northern Ireland, remove it from Northern Ireland. So that is an example of a criminal lifestyle offence, a Schedule 2 criminal lifestyle offence. And Section 328 offences, entering into an arrangement which facilitates the acquisition, retention, use or control of criminal property by or for another person, that also is a Schedule 2 offence. It's an automatic criminal lifestyle offence. This particular offence always puzzles me a little bit because I ask myself, what would happen if you entered into an arrangement which facilitated the transfer or retention of your own proceeds of crime? So you're not doing it by or for another. Can you be prosecuted under Section 328 for entering into an arrangement when you are yourself the person who has created the proceeds of crime? And I think the answer is yes, because the essence of the arrangement is that it involves more than one person. And you are going to give control or use of your criminal property to somebody else as part of that arrangement. So I think it is nevertheless a Section 328 offence, even if it's your own criminal property. But the offence is entering into an arrangement facilitating the acquisition, retention, use or control of criminal property by or for another person. So those two money laundering offences are Schedule 2 criminal lifestyle offences. But there is a further money laundering offence in POCA, which is the Section 329 offence, to acquire, use or have possession of criminal property. And that is not a Schedule 2 money laundering offence. So be aware of that if you're dealing with a Section 16 statement where there is only a Section 329 offence of acquire, use or possess criminal property. That is not of itself a money laundering offence. Not of itself, I'm sorry, a Schedule 2 criminal lifestyle offence. Of course, it may become a criminal lifestyle offence if the benefit is more than £5,000 or at least £5,000 and the offence goes on for at least 6 months. But it's not a Schedule 2 offence. So remember, a mere courier does not obtain the property in his possession. See the case of Allpress back from 2009, which does actually survive the Supreme Court decision in Weyer. So somebody who is merely handling money, let's say, or other criminal property on behalf of somebody else as a mere courier does not obtain the property in his possession, and therefore that will impact upon his benefit in confiscation. But a money launderer who does obtain the laundered property in the course of laundering it will have a benefit of that property, even though he does not retain it. There's a difference, as we know, between obtaining property and retaining property. So, for example, a launderer who passes money through the banking system will have obtained that property in the course of his passing it through the banking system, and therefore he has the benefit of that property. His benefit is going to be based on the amount laundered, and as we've said, that may be greater than the benefit of the crime which generated the original criminal proceeds. Again, reference here to Fulton, the case I talked about a few minutes ago. So let's consider, just to make this a bit clearer, let's consider two alternative scenarios. Peter, let's say, has £100,000 in cash, which is the proceeds of a bank robbery. He asks John to carry the cash in a hold-all to Southampton and there hand it to a man called Mark. And Peter says to John that he will pay him £5,000 for doing this when he returns, because that cash is proceeds of crime. So at this point, John obviously knows that he has a hold-all of £100,000 in cash, which is proceeds of crime. He knows or suspects, and really he knows, doesn't he? Let's suppose that John is arrested on his way to Southampton in possession of the £100,000, and he's subsequently convicted of a Section 329 offence of possession of criminal property. What's going to happen in confiscation? Well, in my view, John has obtained no benefit for confiscation purposes. He's not obtained the £100,000 because he is a mere courier of that cash. And he's not obtained the £5,000 fee because Peter's not paid him. Peter, if you remember, was going to pay him after he got back. So actually, John has obtained no benefit for confiscation purposes. Now, second scenario, a similar situation. Peter has £100,000 in cash, in which is the proceeds of a bank robbery. So exactly the same start point as we had before. He asks Joanne to deposit the cash in her bank account and transfer it to a bank account held by Mark. So in effect, what we're doing here is exactly the same thing. We're transferring £100,000 from Peter to Mark, which is the proceeds of crime. And Peter says he will pay Joanne £5,000 for doing this because the cash is the proceeds of crime. So Joanne knows, or at least suspects, that this £100,000 is proceeds of crime. She's going to put it in her bank account and transfer it to Mark. Joanne deposits the cash in her bank account and transfers it to Mark. But let's suppose the bank makes a suspicious activity report and Joanne is arrested and subsequently convicted. What's she going to be convicted of? Well, she's probably going to be convicted of transferring criminal property, which is the section 327 criminal lifestyle offence. In my view, Joanne has obtained a benefit of £100,000 for confiscation purposes. And the reason she's obtained that £100,000 is because she has deposited it into a bank account which she holds and controls. So she's not become a mere courier. She has, in a sense, become the owner, very temporarily perhaps, but the owner of that £100,000 when she has banked it in her account. And because of that, she has obtained that £100,000. And because of that, she has a benefit of £100,000 for confiscation purposes, even though she doesn't retain that money. So she's obtained the ownership of the money, albeit that she promptly transferred it on to Mark. So Joanne will have a criminal lifestyle as she's committed a Schedule 2 offence, and she will also have a benefit of particular criminal conduct of £100,000, in contrast to John's position, where he was just a courier with a hold-all full of cash. So it does seem that we have two, you might think, somewhat unfairly contrasting outcomes for John and Joanne. But the reason is that Joanne obtained ownership, albeit temporarily, of the £100,000 in cash, and John never did. How can we help? Well, Bartfield's Forensic Accountants remains fully staffed, undertaking legally aided and privately funded criminal and civil forensic accountancy work. And I am today, for the first time in terms of these webinars, I'm today actually in the office in Leeds doing this webinar. It's relatively easy for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities. And we remain, of course, readily contactable by phone, email, and online video links. The website, which is recently updated, is full of useful information, accessible, of course, 24/7. You can find more on this topic and other topics on the website. The address is there. And this and the previous webinars can be found in the seminars section of that website. We will send you a recording of this webinar so that you can review it again if you want. And if you've any questions, do please email me. There's the address there, and I will be more than happy to help you as much as I can. So, thank you very much for your time. I hope you found this useful, and we'll see you again in a fortnight when we shall be discussing some more confiscation case law. Thank you again.